5 seconds. After remand, their case was heard by a learned single judge of Punjab and Haryana High Court. The learned single judge, by order dated March 10, 1995, dismissed the petition filed by the respondent number 1. Thereupon, the respondent number 1 challenged the said judgment by filing a letter patent appeal number 674 of 1995. During the pendency of the appeal, respondent number 1 filed an application on August 27, 2004 under section 151 of the Code of Civil Procedure for bringing on record certain documents in support of his claim that service rendered by him in the state of Punjab should be taken into consideration for the purpose of determining qualifying service rendered by him in the board. The record further showed that he filed another application for bringing on record certain documents in support of his claim. The division bench of the High Court noticed that those documents were neither considered by the learned single judge nor by the board, and therefore the division bench, by an order dated August 24, 2005, directed the board to consider the case of the respondent number 1 for the grant of pensionary benefits in the light of new documents filed in the appeal within 4 months from the date of the order. After passing the said order, the hearing of the appeal was adjourned. Pursuant to the directions given by the High Court, the board reconsidered the case of the respondent number 1 for grant of pensionary benefits in the light of the documents produced by him on the record of the appeal, and rejected the said claim by a speaking order dated November 16, 2005. The order passed by the board was produced before the court hearing LPA number 674 of 1995. The main ground on which the claim of the respondent number 1 for grant of pensionary benefits in the light of the new documents was rejected was that the case of the respondent number 1 was not covered by Regulation Circular number 54 of 1985 bearing memo number 257861 Regulation 6 Volume 5 dated November 25, 1985, because he had rendered service in the work charged capacity outside the board, that is, in the departments of the state government, namely Bhakra Management Board and Beach Management Board, and that the said service was a non-punishable service so far as the state government was concerned. The division bench considered the order dated November 16, 2005, passed by the board rejecting the claim of the respondent number 1 as well as Rule 317 of the Punjab Civil Service Rules and the full bench decision of the Punjab and Haryana High Court rendered in Keshar Chand versus State of Punjab and ORS 1988 5 SLR 27. The division bench noticed that the full bench of the Punjab and Haryana High Court had struck down Rule 3.17 of the Punjab Civil Services Rules, which inter alia provided that period of service in work charge establishments shall not be counted as qualifying service. After noticing the ratio laid down by the full bench of division bench concluded the rule with excluded the counting of work charge service of an employee whose services were regularized subsequently was bad in law, and therefore the conclusion of the board that the case of the respondent number 1 was not covered by circular dated November 25, 1985 because services rendered by him as work charged employee in the departments of the state government was non-punishable service so far as the government of Punjab was concerned was wrong. In view of the said conclusion, the division bench by the impugned judgment has allowed the claim of the respondent number 1 to include work charged service rendered by him with the state of Punjab for grant of pension and directed the board to count the said period for determining qualifying service for the purpose of pension, giving rise to the instant appeal.